canceling social media accounts, attaching trackers to people's bodies because the government deems them undesirable, is not the way a democratic country goes about treating its citizenry.
The bureaucracy right now is functioning in a way that it's completely independent of the assembly. So if you make a post on social media that the trash has not been collected, right? That could be misinformation. So essentially, what this law is essentially trying to do is empower the bureaucrats to punish you.
And they're
Distinction to
becoming
what
judge, jury, and executioners in one go. So you're watching DigiPod on DawnNews English, and I'm your host, Usama Khilji. Tracking devices on the ankles and wrists of citizens, cancellation of social media accounts of citizens, and complete impunity and authority in the hands of bureaucracy to proclaim anyone an offender within the Punjab province. These are just some of the punishments that the Punjab Assembly's new bill that was being debated throughout the past couple of weeks and ultimately taken back by the Assembly on the request of the Punjab Assembly Speaker resulted in. Now, what does this mean in terms of our democracy in Pakistan? What does it mean in terms of accountability and separation of powers? And what does it mean in terms of fundamental rights of Pakistani citizens whose citizenship, whose social media activity, and whose freedom of movement, freedom of speech are all threatened by this particular legislation? So, to talk about this, we're joined by Ali Javed, who's a lawyer, practicing lawyer based in Lahore, who also wrote a piece for Dawn on this particular bill. So we'll hear from him what this law says, what the issues with it are, and what the way forward is. Thank you for joining us, Ali.
Thank you for having me, Osama.
And perhaps you could break down what the main features of this proposed legislation in the Punjab Assembly were.
So this law, what it does is, at least ostensibly, its stated purpose is to control crime and to give the state a tool to control habitual offenders. But if you look at its structure, that is not what's happening. The first thing is that under this law, all the conduct it is criminalizing, it's already criminalized under Pakistan. Because Pakistan, incidentally, has one of the most statutes concerning criminalized conduct anywhere in the world. So it talks about theft, that's already criminalized. It even talks about cruelty to animal, that's already criminalized. Obscene language is also already criminalized. Obscene conduct, spreading misinformation under the defamation law, it is both a civil and a criminal offense. So the criminalized part, that's already managed. What this law is doing is changing the adjudication method for determining whether you've done something that is that deserves punishment or not. So under our other regime, all these statutes, what they demand is that the government can prosecute you, but the punishment has to be given by a judicial officer or by the judiciary. Under this law, they've made these committees that, for all intents and purposes, can punish you for conduct based on inquiry report. And these committees comprise of police and bureaucrats, and there's going to be one person from the Federal Intelligence Agency. That could be from the IB or our other intelligence agency. So essentially, what this law is essentially trying to do is empower the bureaucrats to punish you. In
And they're
distinction to
becoming
what
judge, jury, and executioners in one go.
Yes, exactly, exactly. So they can kind of generate the inquiry report, which will be the charge sheet, so to speak. And based on that charge sheet, they can also find you guilty. So that's thing number one. Thing number two is that under this law, even after they punish you for what has been broadly termed as antisocial conduct, and we can get to the contours of what that is, your appeal also lies within the same structure for the first three times. So you're gonna first get punished, then you're gonna appeal to another committee, which is also going to be comprising of bureaucrats, but senior ones, then you're going to appeal to another committee, which is once again going to be comprised of the same bureaucrats. Then the third appeal, you get to the Secretary Home Department. The fourth appeal is going to be in front of a kind of a quasi tribunal, which will be headed by a retired judge, but it will be accompanied by two retired bureaucrats. So essentially, the structure is kind of self-enclosed in which the bureaucracy is going to decide your future. The second thing about this is that some of the terms which have kind of been made criminalized, so to speak, they're so broad that they've completely been left to the imagination of these committees. So, for instance, annoying people is one of the parameters of antisocial conduct. Now, what is exactly annoying? The term is incredibly broad, and the proposed legislation makes no attempt to kind of further define it. Spreading misinformation is another one of these things. Abusing public is also a part of the antisocial conduct parameters. And so the problem is that what does it even mean to abuse someone? Will an exclamation, which has been delivered a bit too enthusiastically, also constitute as an abuse and all? So bottom line is the parameters of what is antisocial conduct are so huge, and the adjudication authority in that case are the bureaucrats, that if they want, it's so easy to get to a person. And I think the real target of this law would be, I would say, quote unquote, undesirables, and we can kind of get to who they are. So this is one part about the law that deals with antisocial conduct. The second part of the law is about habitual offenders, and there's a separate track for them. And I think with habitual offenders, it's important to clarify that generally speaking, what you would kind of intuitively think about once you're thinking about habitual offenders are hardened criminals. And with that, you'd expect that the minimum threshold would be 3, 4 convictions for heinous conduct. But over here, habitual offenders, there are 2, 3 kind of definitions, but one of them is that you should have been charged by the police/prosecution, and that is enough. And by charge, what I mean is a challan must have been submitted against you. And the way
So no
Pakistan's criminal justice,
conviction.
no conviction. And the challan is something which is submitted against you by default if any FIR has been cut against you. Amusingly, sometimes the defense lawyers are saying, can you please submit the challan? Because it is only after the challan that you get bail in certain cases. If they've kind of charged you with a particularly heavy provision under the PPC, then the judges sometimes say, can you please ask them to bring the challan so that at least we can make a prima facie assessment of what the evidence is against you. So it's the defense lawyers that are saying, please submit the challan so that we can either get acquitted or we can get bail. So that's the threshold for ascertaining what a hardened criminal is. The second threshold, and all of these are independent, is credible evidence. Now, what is credible evidence? We don't know. So even with the habitual offender track, uh, if they essentially want to get you on that, there's honestly nothing that can stop you. With the habitual offender track, it's the district magistrate. So in this, there is some role of the judiciary in which the district magistrate will kind of determine whether they've made the case or not. But there are two interesting things. Number one, there's already talk that in Punjab they want to empower the bureaucrats with with magisterial powers. This has already happened in the past, and there's a chance this may happen again. But the second thing is that you see, a judge is also supposed to adjudicate based on what the law is telling this judge. Right now, in the proposed bill, what the law is telling the magistrate is that if there are these two things, he or she is a habitual offender. So the judge will also look at the fact that the law states that if there are 3 challans or 2 challans, then you're a habitual offender. And I'm supposed to exercise my own independent moral judgment about the kind of person you are. I'm going to follow the law. So, in that sense, the law also almost bounds the district magistrate to declare you a habitual offender, provided that these things are met. And those things are incredibly easy to meet for any government. Now, lastly, once all of this happens, what are the consequences? So, for the antisocial behavior track, the government or the intelligence committee can recommend a host of very punitive measures starting from freezing your bank accounts, seizing your immovable property, confiscating your passport, canceling your CNIC. So all of these are provided. And the issue over here, purely from a, I'd say, equitable or constitutional perspective, is that one of the key principles of equity is proportionality, right? So whatever you've done, the punitive measure that is being imposed, there has to be a nexus with some sort of either remedial conduct, proportional punishment. And so the questions that arise are, how is canceling your CNIC linked to any kind of punitive conduct? Essentially, what they're doing is canceling your citizenship, right? Because that's the one local citizenship instrument that you have to prove it. So why, let's suppose I have, in fact, robbed someone. Why does my CNIC need to be canceled? This doesn't happen anywhere else in the world. Secondly, confiscating your passport. Am I a flight risk? Like, what's the reason here? Thirdly, seizing your bank account. Now, there's a, like in jurisprudence, you obviously have to recompense for the harm that you've caused. It's quantified and then you're asked to pay. But seizing every single bank account that you have is neither here nor there. It's completely punitive, it's draconian. So, with these punishments, also, it seems like they've gone completely overbroad. Like they're completely overbroad. And you just can't help but feel that the purpose is to make the people feel afraid that you shouldn't cross the state. Because there is no notion of proportionality, no notion of kind of the constitutional principles of due process, nothing like that. So
No, and
this
this
is
is
broadly that.
interesting because in the post 26th and 27th Amendment Pakistan, what we've seen is that the executive has a major hold over the judiciary. But despite having that hold, it seems that the government seems to want even more power and even more impunity to be able to prosecute, punish people that they want to punish. And the intention, in my mind, appears to be to punish dissidents or punish those who perhaps are too critical of the state or perhaps are becoming a challenge to the state, right? So maybe we can talk a bit about the intention behind this. But Ali, in your piece, you've also commented on the history of this law and how in the British colonial era we had similar provisions, and then even under military dictatorships we've had similar provisions in the law. How do you see the evolution of that into, the current state of affairs, and for the Punjab government to bring this, seeing as the Punjab government's already passed other, draconian legislation like the Punjab defamation law?
Right. So I think the link that I was trying to draw was that there's definitely a bureaucratic continuity, notwithstanding independence and notwithstanding that sometimes we're in periods of kind of military coups and then at other times we're ostensibly democratic, but the bureaucracy remains the same. And their mindset about what it means to govern and what are legitimate instruments through which they can affect public order is also pretty much the same. So with the British, what we saw was that the colonial officers or the colonial administrators, their focus was on maintaining public order because they were an occupying public unrest was not good for colonial extraction. So they would ensure public order, and they were not concerned about the means through which they were doing it. So, with a lot of these laws, interestingly, even in the 1800s and 1900s, they did not introduce any such legislation in the UK, right? This legislation was only meant for the colonies. And with this legislation, there obviously due process is something which it's embedded in their history on account of the way they transition from a monarchy to a constitutional monarchy, or so to speak. That was never their concern here. So the colonial administrations could, as you mentioned before, be the judge, jury, and executioner. So the punishments were prompt, and any undesirable or dissidents could be taken out immediately. So this is the background. Some of the laws that I mentioned were the Criminal Tribes Act, which was essentially aimed at pastoral communities. They kind of were developing these canals. And so for that, there had to be a lot of displacement of people, and new people were coming in so that further lands could be cultivated, which was important for them from an economic perspective. So obviously that caused displacement. A lot of pastoral communities were affected. So this was one of the laws that was there to ensure that, so to speak, we can take care of the dissidents very quickly. In the same way, once the previous their iteration of this law came, the predecessor of this law that was introduced during colonial times, over there also, so two things. Interestingly, even they did not have such draconian measures as has been proposed by our government. But even over there, the issue was that if we want to take care of something, if we want to take care of someone who's being particularly belligerent, we don't need to kind of ask our prosecution, take him to the judge. We have a ready-made toolkit of certain measures that we can implement. So once again, if you want to kind of articulate the rationale from the most sympathetic view towards colonialism, I think you'd say that public order is the most important thing, and we can't
Hmm.
afford any any disturbance. So that's why we need to do this. And you know what? We're also building railways and we're doing all of these things. So give us a helping hand. Now, we're now in 2026. And in all honesty, if you have to make a rationale for this law, it's almost impossible to argue that it is in line with our constitution or with any sense of like any notions of kind of modern concepts, which like I don't know how modern due process is, but let's say it is now even more well established. So the only rationale you can actually give is pretty much the same, which is public order is really important and the bureaucracy needs to have a free hand. And a word which we've kind of heard so much ever since 1947, which is writ of the state needs to be preserved at all cost. And that's something which this law also mentions. So I think the link with coming back and kind of connecting this, the link with colonial times is that the ideology, the mentality, and honestly, the bureaucracy is still the same. And therefore, the law is also pretty much the same. All they've done is given it a modern touch by including things like electronic surveillance, these bracelets to monitor your movement, and social media was not there. So all of this has been covered.
So I'm
But
glad you mentioned social media. Maybe you could run us through a bit on what the social media aspect of this law is.
right. So I mean, the intelligence committees almost have what I would call a blanket power to take you offline. They can confiscate your uh, electronic equipment through which you would go online, which are your laptops, your phones. They can remove your online presence. And over here, I think the focus is domestic with these companies. They also, for commercial reasons or ethical reasons, the jury's out, but they do resist uh, at times national pressure to censor. And since the servers are abroad, the government finds it a bit hard to bring them into line. So with this law, I think the hook here is they'll just kind of get the person, take his laptop, and then pretty much on gunpoint ask him to delete his account because the person will be here. So once again, we've talked about this, but basically, defamation law exists, right? So if any person is saying something that is defamatory, and there is already a mechanism of holding that person accountable, especially under civil law, in which there can be a trial, and if that person is judged to have actually indulged in defamation, he can he or she would be liable to pay damages, right? So that system exists, and they've also turbocharged that system because a new defamation law came, and we can talk about that some other time. But with this law, this is just an intelligence committee saying you've said something. Here's the inquiry report, and now you have to do these things. And if you don't, we'll send you to jail.
So the antisocial behavior could be comments or posts on social media. And based on those, your social media presence can go away and you can be deemed a habitual offender. Is that correct?
Yes, 100%. And also just the just to give it a tangible context, right? A lot of the people who are in these committees also affect your daily life in other ways. So for instance, the DC is we have no functioning local government. So they pretty much call the shots once it comes to municipal administration. So if you make a post on social media that the trash has not been collected, right? That could be misinformation. And it's the same DC who would actually be the convener of this intelligence committee. You have a problem with a housing society being built. You think in one of the cases the police acted with a very heavy hand, which in Punjab it has been for quite some time. So with all of these things, it is these people also have such a direct power over you, in kind of taking you to task for comments which you would perceive as constructive criticism, and these people may perceive as harming the writ of the state, so to speak. So yeah.
And this is a pattern that we've been seeing, right? We spoke about the defamation law, but we've also seen that in the past, say, 3 years or 4 years, the maintenance of public order ordinance, the MPO, has been used to detain political or social or human rights activists preemptively. And what we've also seen is that people have gone to jail simply for posting their opinions on social media. What we've also seen is amendment to PICA, for example, in which now anyone can go to jail for sharing false or fake information for up to 3 years. And like you said, the definitions in these laws are so vague. In those laws, we see very vague definitions as well. And then we've already talked about how the judiciary itself has fundamentally changed in the past few years. But maybe we can walk a bit through, talk about the lawmaking process that this law took in the Punjab Assembly, because reports suggest that the Speaker was also unaware of the law, and perhaps some committee only worked on it. But what are the procedural issues with coming about of this particular law, and what is the current status?
Right. So the law was laid before the assembly and then it was referred to a committee. Once it was laid before the assembly, the speaker was apparently not present. The deputy speaker may have referred it to the committee because if the speaker is not available, it's the deputy speaker that presides over the assembly session. Then it went to the committee. Now, the opposition and chiefly PTI have boycotted all committees. So the committee was only full of treasury slash government members. And I think they passed it in pretty much a single day. And then it hadn't been laid before the assembly, but then word got out, and the one of the PTI opposition members, Rana Aftab Saab, he got up, and during the budget session, he raised a point of order and said that I understand that this bill has been passed by the committee and it can be passed by the assembly any day now. So I want to raise serious concerns over it, and that is how as per the footage, I think all of us saw, that is how the speaker became aware that there is such a bill that has been passed by the committee, and it can be like if it goes here, the government has a clear majority now in Punjab. So if the instructions are to vote in a certain way, they will. And then I think he raised a hue and a cry by kind of linking the architecture of the bill to what was there in colonial times. And I think he then went and met the chief minister based on all of this. I'm kind of basing on news reports that I've read. And he told or kind of managed to persuade the chief minister that this bill will be very unpopular and we don't want to go that route. And with the assembly, I would say there's also a bit of another background because right now, there have also been a lot of speeches in the assembly against CCD, the crime control department, because what's been happening is that with a lot of the members, the MPAs in their constituency, CCD has also been carrying out sanitizing operations. And so they're very, very unpopular. And I think the government MPs also feel quite helpless in front of all of this because I think the voters have an expectation that you will be able to do something about this. In a lot of the cases, people already know before that which people have been marked and what's going to happen. And notwithstanding that they go to these MPAs, both the opposition and the government, uh, there's nothing that they can also do because coming back, the bureaucracy right now is functioning in a way that it's completely independent of the assembly, and it's a very centralized setup. And so there's basically the assembly, they've been grumbling against the increasing empowerment of the bureaucracy, which is reaching new heights. And there's a very big sense of deprivation that if they're not listening to us, then what's the point of us even being MPs? So that was also one of the contexts in which they were the assembly and the speaker, who also obviously gets to hear a lot of these things from his MPs, acted against this law.
Right. So the parliamentary oversight function of the Punjab Assembly seems to be undermined by the bureaucracy in the eyes of the constituents, and they're complaining to their representatives. And hence, when a bill comes empowering the bureaucracy further, it's created panic among the members of the assembly itself. Is that correct?
Yes, 100%.
That's interesting. And currently, as it stands, we're told that the debate on the bill has been postponed. What does that mean? Because it seems like this draft, they said they would revise it, but what's the current status of it?
So it has been withdrawn by the government for now.
Okay.
That's the official line that they've taken. And they've also said that if we bring it back, it's an if, we're going to ensure that it is in line. We're going to incorporate all the criticism. But right now, the assembly is also on vacation. So even if they wanted to bring it, uh, they would have to pass it as an ordinance, because the assembly, I think, is going to reconvene in August. And what they do in August is honestly anybody's guess, because from the trend that we've seen so far, the trend of kind of empowering the bureaucracy, completely sidelining the elected representatives, and running the province almost entirely through the bureaucracy. So I'm not sure what they're going to do in come August.
Right. And then what we're also seeing is, an increased use of the bureaucracy by, say, the central government. So is this also a conflict between, say, the central government that's run in Islamabad versus the provincial governments in terms of, devolution and autonomy of provinces?
With this, I think there are some overlapping powers that are covered under federal law, and now this provincial law is also giving kind of jurisdiction to, or this proposed bill is giving jurisdiction to provincial intelligence committees. But I think the bureaucracies are pretty much aligned, the federal so for instance, in the intelligence committees, one of the members is supposed to be a representative of the federal intelligence agencies, which could either, as I've mentioned, be the IB or the ISI. So I don't think that the law generally would lead to such an issue, because I think the bureaucracy overall in the federal and the province, I think the bureaucracy that's calling the shots are coming from the same cadre. And I think there is a great deal of coordination between them with respect to how we're going to proceed.
So Ali, to sum up, in terms of the proposed law that now seems to have been withdrawn, um, but we know that it could come back anytime, considering the way legislation has been done in the past few years. What would you recommend the way forward should be in terms of the lawmaking, whether stakeholder feedback is important or not? And then, ideally, if this issue was to be addressed, and you've already mentioned how a lot of the issues are already addressed by different pieces of legislation. What would the ideal way forward be?
Right. I think the way legislation's happening right now in this country is obviously in a very insulated, insular manner, where a bill is drawn and it's passed without there being any room for discussion. So the way it should be legislated is that there should be a draft that should be circulated, comments should be solicited, then it should be presented before the assembly, and there should be at least 3, 4 days of debate. And even if the opposition doesn't have the numerical strength to stop the passing, their concerns should be noted and addressed, because the opposition has said this multiple times. This government will also be in the opposition someday, very soon in the medium term. And then this law, they'll also have to face the brunt of this law. And with Pika, we've already seen how it happens. The party that brings it as a sword is on the receiving end oftentimes. So there should be a consultative process. At the same time, the way the law currently is, it takes a certain kind of confidence to pass it and not expect it to be struck down, significant parts of it struck down by the judiciary on account of being ultra vires the Constitution. And the concerning thing is, where is this confidence coming from? Because we have quite well established jurisprudence regarding separation of power. The executive cannot punish; it has to be the judiciary. Some of the other things I mentioned about, like proportionality, like the accused party being having the right to due process and having the right to be heard. Your appeals process involving requiring the judiciary to be there. So there's a whole bunch of constitutional problems with this issue, which should, based on what our jurisprudence is, lead it to getting struck down. So there needs to be a more consultative process to ensure that all the concerns, which honestly right now are so much that it's really hard to imagine this bill being passed in any form that will not be an issue, considering what the basic architecture of this bill is. But notwithstanding that, if it is to happen, there needs to be significant safeguards that need to be included before one can even think of having a discussion on merits about whether this bill has adequate safeguards or not. And secondly, vis-a-vis the judiciary and our constitutional scheme, they have to ensure that it is in compliance with it. And right now, it 100% is not.
Well, thanks very much, Ali, for joining us. We've discussed how the bill essentially violates many tenets of fundamental rights in the Constitution, but apart from that, also due process rights, right, where a punishment cannot be handed out by the executive, by the bureaucracy. The judicial process, the trial has to go in place. And then at the end of the day, draconian measures like canceling citizenship, canceling social media accounts, attaching trackers to people's bodies because the government deems them undesirable is not the way a democratic country goes about treating its citizenry. And what we've also discussed is how the lawmaking process begs a lot to be desired. So hopefully, this is a good lesson for the government of Punjab to take forward this issue in a more constructive manner, which respects the rights of citizens, which also keeps in mind the human rights obligations of the government and Pakistan's commitments under international law, which are also linked to our economy through the GSP plus status the European Union has given to Pakistan in terms of trade concessions. So we hope that all of these things will be taken into account by the government before it moves forwards to bring about a bill that impacts every citizen and that gives impunity to the government to act as it wishes against people it considers undesirable. So that's it from today. Thank you for joining us, and we'll be back with another episode of DigiPod on DawnNews English. This is your host, Usama Khilji, signing out.